presentation that's really content heavy. Unfortunately, our projector is not working, so you're going to want to follow along on your handouts for the PowerPoint. We have some more up here if you weren't able to get one when you first came in. So please hold all questions till the end, because we do have a lot that we want to get through. All right?
All right, well, thank you everyone for having us, and thank you so much for your time and interest in this topic today. This training is coming out of discussions that I've had with some of the supervisors here, as well as with CLC and County Council, about sort of what response we need at our local courthouses in the Trump era to protect immigrant families. And my name is Lindsay. I'm the Executive Director of the Immigrant Defenders Law Center. We're a social justice law firm that protects immigrants who are in deportation proceedings. So we are essentially what a lot of you do. We're defense attorneys in immigration court. You may or may not be aware that most or all immigrants are not entitled to have an attorney represent them in court. That is paid for by the government. They have a right to have an attorney at their own expense, but for most detained immigrants, and we'll talk a lot more about that later, for most detained immigrants and most immigrants, that is simply not something that they're able to afford to do, so many people go unrepresented. I found in my organization with the idea that no immigrant should go into court alone, that there should be a constitutional right to have an attorney present to defend you, much like we have here in dependency court and in criminal court, and so that we would like to move Gideon forward for immigrants. So that's what I do. And Jordan?
Yeah, I'm Jordan. I'm an Equal Justice Works Fellow and Immigration Attorney at Public Counsel. And I work specifically with parents in immigration detention who either have open dependency court cases or who are at risk of some sort of involvement with dependency court, either separate from or because of their time in immigrant detention. So I'm going to address that specifically today, but I just wanted to say at the beginning I'm happy to be a resource to you all if you have detained clients. I'd love to hear from you. So, let me know.
And we're going to try and go through the slides pretty quickly because we also want to leave some time at the end for you to ask questions. We know that there was a snafu a few weeks ago where there was a lot of panic in the courthouse because of it appears now to be a false report of ICE being here at the courthouse. So one of the other things that I'm going to talk about is what's being done here at the courthouse, both by supervisors in your office, as well as other people who are on a new task force that we've created to really streamline that process so that we can respond if ICE does have enforcement actions that take place here at Edelman.
So just a quick overview. As you can see on your slides, we're going to just give a quick update on sort of what's been happening since November and since January, the inauguration specifically, as to immigrant rights and immigrant enforcement. Do a super quick kind of know your rights overview and highlight the high-risk enforcement categories among your immigrant clients. I'm going to talk about working with detained parents, and then Lindsay's going to give an overview of immigration law remedies that might some of your immigrant clients might benefit from, and then also talk about community resources, and then we hope to leave lots of time for questions.
Yeah. And we did give you some handouts, two of them, one's in Spanish, one's in English. Feel free to make tons of copies of those and give them out to any of your undocumented or even legal permanent resident parents who you're working with. There's one in Spanish, one in English, but they're the same document. Those are put together by a great organization called the Immigrant Legal Resource Center, and they have a really comprehensive list of resources on their website. So I suggest that you take a visit there too if you're more interested in more information. There's also community resources that are here in this community that can help people with some of the forms of relief that I'll talk about a little bit later. So that is another thing that I encourage you. It's something I put together. It tells you the different organizations here in Los Angeles and the different types of cases that they take, but I encourage you to make copies of that and give it out to your clients as well. So I'm going to actually just talk about some things that you may know a little bit about because they've already been in the news. We basically, since the inauguration, we've had 3 executive orders come out that relate to immigration enforcement. In addition to the 3 executive orders, we had in February some rules and regulations that came out from the Department of Homeland Security to let us know how these new executive orders would be implemented. So the first one, which I'll cover just very briefly, many of you have probably heard about the Muslim ban executive order, the travel ban. This was signed on Friday, January 27th. This was actually the last of the 3, and I'll cover it very quickly because for most of your clients here in LA County, this isn't going to be a huge issue. It's mostly for people who are entering the United States. from those countries, but what is unique about it is that it does apply to people who otherwise would be coming legally into the United States, so people with valid visas. And for people who are from the 7 countries affected by the ban, it could have an effect if they leave the United States. They may not be able to enter. So the 3 countries that it affects, or the 7 countries, are Iran, Libya, Somalia, Sudan, Syria, and Yemen. And basically the Muslim ban right now has been put on hold by a court in Hawaii, and there's litigation all across the country. Lawyers got very busy very quick, thank goodness. But there is, if you have a client who for some reason you think is affected by this, in the slides we do have a number for public counsel, which is a hotline number that you can call. In the days after the Muslim ban went into effect, our organizations, IMDEF and Public Counsel, along with the ACLU, spent basically 2 weeks at LAX helping every single family that filtered through. So this is a big issue. It's going to be an ongoing issue, but again, it just affects a very small number of families. So I'll move on to the other ones, which are going to affect, unfortunately, a much bigger group of people that you're working with. So I'll actually skip the slide on DACA right now and talk about the Interior Enforcement Memo. This was actually signed 2 days prior to the Muslim ban. It got much less attention than the Muslim ban because that was so clearly unconstitutional. But this ban is still in effect, or this order is still in effect. And really what this does is it announces what the new priorities are for people who are going to be subject to immigration enforcement. And really, sadly I have to tell you, this is basically, it took away all priorities and makes everyone a priority. And so anyone who is undocumented in the United States is now a priority for enforcement under the Trump administration. In addition to that, anyone who's committed a criminal offense, anyone who has pending criminal charges, and this is one that I think is particularly important for people who have cases in dependency court, anyone who may have committed acts that would constitute a crime. Even if you haven't been arrested or have not been charged criminally, certainly what is happening in dependency court could be used against you for the purposes of immigration enforcement. Now, for any of the immigration, or people who've had any experience with immigration law in the room, you may be wondering what that means, because oftentimes you have to have a criminal conviction for it to actually affect your immigration case once you get to court, and that's true. But what this is saying is that for the purposes of immigration enforcement, for them to bring a case against you to allege that you're undocumented or anything else, just having committed acts that could constitute a crime is enough for them to consider you a priority under the Trump administration. Again, committing fraud before a government agency, having abused any public benefits programs. This is a big one because we actually have very little idea of how that will be played out in public or in practice. It could be possible that abusing a government program could be accepting benefits when you were not, when you thought you were eligible, but you really weren't eligible. So this is another one where we're worried about the slippery slope of how many people could get entangled under the public benefits enforcement issue. And then the people who are most at risk, who are at the very front lines for immigration enforcement, are those who already have a final order of removal. So if you have a final order of removal from an immigration court, and unfortunately this can happen very easily that you have a final order, because this could be that you crossed the border in 1998, happened to be deported and crossed back the next day. And especially prior to 2001, there was much more, it was much more fluid at our borders, and so a lot of people were fingerprinted and have outstanding orders of removal, and they may not even know. Additionally, sometimes people are caught upon entering, let go into the United States, issued a notice to appear in immigration court, and later don't receive notice of an updated hearing. They don't go to that hearing, and they're ordered removed in their absence. So there are a lot of people in our community, and in Los Angeles in general, 1 in 10 people are undocumented. And so within that group of that 1 in 10 in LA County, there are a lot of people who have those final orders of removal. So unfortunately here in LA, we're going to feel the impact of this much more quickly than other places. And there's also another issue with within this executive order, that the families of unaccompanied children who came to the United States, and we've had a huge surge in the number of unaccompanied minors who've come to the U.S. Since 2014, They're mostly coming from the northern triangle of Central America, so El Salvador, Honduras, and Guatemala. This is one of the most violent regions on earth. El Salvador is the murder capital of the world because of the transnational violence that's happened with MS-13 and 18. These gangs have created a real severe humanitarian issue. So a lot of families are paying for their children to flee that violence and come to the United States. In an instance where that happens, it's now believed that those families may be targeted both for enforcement and criminal prosecution for smuggling their own children into the United States. That's a big change that we've never seen before. So the other executive order, which I'll just cover very quickly, was also issued on January 25th. This executive order basically goes into the idea of creating a deportation force under the Trump administration. So we're going to see a huge increase, up to 10,000 more Customs and Border Protection officers at the southern border. This is also the border wall executive order. And in addition to all of that, we do expect that there will be a huge rise in the number of immigrants who are subject to detention. So we know that they're going to be hiring 5,000 new ICE officers to be here in our communities, and that they are expanding the number of beds that are available for detention. So over the last few years, even under the Obama administration, there's always been a quota of how many people the federal government agrees to have in immigration detention at any time, and that number is going to increase. So we expect to see more people who would have been allowed to be out in the community and either bonded out of detention or never detained in the first place, mothers with children, breastfeeding mothers, fathers of U.S. citizen children, people who have not been convicted of a crime. We expect them, now that they're labeled as high enforcement because they've maybe committed acts that could constitute a crime, or because they are undocumented, any of those people, now that everyone is a priority, will be subject to detention. So what Jordan's going to talk about a little bit later in this presentation is going to become all the more important for you and your clients, because you will likely see an uptick in the number of parents that you have who are in immigration detention, not only fighting their removal case, but also fighting to get their kids back. So, do you want me to do the Know Your Rights, or am I?
Sure.
Okay. So does anyone have questions on the executive orders themselves? Or did you have anything you want to add?
No.
So what I'll talk about now is a little bit about the sort of know your rights that we are giving to clients. And on the slide you'll see that I just gave it a few different offices here. One is Coalition for Humane Immigrant Rights of Los Angeles, also known as CHIRLA. Another one is the Central American Resource Center, CARECEN, and then Asian Americans Advancing Justice. Those are 3 community-based organizations that currently have funding to do large-scale Know Your Rights presentations for your clients. I would strongly recommend that you tell your clients to go to those agencies and sign up. They're doing them almost every day of the week. I think CARECEN might do them Monday, Wednesday nights, and CHIRLA does them on Tuesdays and Thursdays. So there's a lot of opportunity out there to have your clients go educate themselves about what their rights are if they are approached by ICE or by immigration enforcement. One of the things that I wanted to kind of talk about here today, which is, oh, go ahead.
Just briefly, does being a sanctuary city, does that cause any type of buffer between ICE and undocumented people in LA? Or, I mean, is there, I guess, a benefit for being a sanctuary city?
So LA has some sanctuary policies, but LA is not fully a sanctuary city, and it's been a point of contention between immigrant advocates and Mayor Garcetti about whether or not we can call ourselves a sanctuary city. There are some policies in place, like LAPD does not stop someone, for example. They won't act as immigration enforcement. In most cases, because of the Trust Act and other state laws that we have, many people are not turned over to ICE by our police departments, but there are a lot of holes in that system, and especially outside of LA County, you see that these are routinely not followed anyway. But here in LA County, LAPD does not have any contact with ICE in the sense that they are not turning people over to ICE. The real issue is that even though LA City might have some policies, the LA Sheriff's Department strongly opposes sanctuary policies in most cases, and they routinely do joint actions with ICE where they'll go out together. And ICE will, in the end, apprehend people, including people who just happen to be in the area where they are. So we won't see it so much on the city level. There are strong policies in place, but it's something that you'll see us on the news all the time at the city council meetings and at the Board of Supervisors meetings trying to push these. There is a really important piece of legislation currently pending at the state level called Senate Bill 54. It was put together by Kevin De Leon, who's the state senator for this area, and that would actually create policies that would make California a sanctuary state. And that's something that's now gone back to the Assembly, and we'll see if that passes. If it does, really what it does, it'll create a buffer between local law enforcement turning people over to ICE and severely limit the amount of time that people can, or the amount of time that people can be held for the purposes of giving them over to ICE. Additionally, it also creates policies for local courthouses, hospitals, and schools to do a study to see how much the state of California can do to keep ICE out of those sensitive locations. But that's something that's still pending, and we'll talk more about the fact that it's a very complicated and sort of unknown area of law of how much local California state and local courthouses can do to keep ICE out of the courthouse. Unfortunately, there's probably nothing you can do to keep them out of the hallways or other public spaces. So one of the things that's really important and would apply to a lot of the families that you're working with, particularly as you close their case, if you know the parents are undocumented, or in cases where a case never actually opens, is that we are recommending that undocumented parents create family preparedness plans. And what this basically means is that they create a plan in the event that they're detained. There are a lot of things that you don't think about that you might need to do that are very simple, but that will be so important to keep kids out of DCFS custody if they're done in advance. One of them is even updating at the parent's school who can pick your child up. If you're the only person who can legally pick your child up and there's no one else that you've designated and you're detained in an immigrant detention and you have no way to contact anyone, no one else will be able to pick up your child from a public school. So I put a link here to the Immigrant Legal Resource Center Family Preparedness Plan. What this plan basically does is it gives the parents all of the information they need to create a power of attorney for someone else to care for their children in the event that they're detained. We are recommending that for some families, especially when they have a prior removal order and we know that they're at the front of the line and the most likely to be detained, that they actually fill out the guardianship paperwork, keep it in their own possession, because I'm sure you've seen cases. I don't know if I mentioned, I was a CLC attorney for 2 years here, so I'm sure you've seen cases where people have to fight to get their kids back because someone files those guardianship papers before the parent's actually ready for that guardianship to go through. So we aren't recommending that they hand those papers to anyone that they would want to do a guardianship, but that they have those done, filled out in a safe space where in the event that they're detained, they can contact someone and tell them where to go get them. So that, in addition to creating a child care plan, there's also finding out where, getting all of your children's documents together, so if there's a medical emergency, someone else can get them medical care. And the reason is that all of this is so important is because once people are caught up in the deportation system, it can be very complicated. And Jordan will talk more about this, but people can end up far from Los Angeles, all around the country. And so you want to make sure that parents have a plan in place for their children, especially if they're at high risk of enforcement because of a prior crime or a prior removal order. So in the family preparedness plan, it's actually a step-by-step process that they can go through, designating a caregiver. It tells you what documents you should have there, shows you how to fill out the power of attorney and or guardianship forms. And additionally, Betzetic, another local nonprofit in town, has opened a clinic to help undocumented parents fill out those guardianship paperwork.
Yeah, two questions very briefly. One is, because what you're focusing on right now are parents, let's say within our system, whose children are on family maintenance, the kids are already in the home of the parent. And when we did the stakeholders meeting, the question I had to county council is, let's say a parent is very concerned and designates someone should their child get picked up. The department has not cleared that person, and I realize that the parent is making that. So what I'm just trying to think that I could see a parent doing that, getting picked up, and then the social worker going out to that home, and that person has a 15-year-old DUI, and they don't have yet the waivers on the DUI, and they yank the kid. But yet it was a family maintenance thing. Are they going to be filing 387s? I mean, how can we jive what you're saying with what happens with people? I mean, the department is not in agreement. Is there anything being done on the department side where they will acknowledge these plans?
So I think if the family's in family maintenance, it is going to be somewhat more complicated, but I think that's a conversation we can keep having with the department of why this is not in the child's best interest to do that. I think also what families can do is, to the best of their ability, it has to be a proper plan that they're creating, and so I think that they can, if they have a case that is open still or on family maintenance, then I think they're going to have to be that much more careful that it's going to be someone who hopefully can pass the department's muster. But really this, in terms of creating a plan where the department can't get involved at all, would really be more for cases where it's getting closed out, cases done, home of parents, and in that case, families really need to have a plan, because especially with a prior DCFS history, if you don't have a plan in place and there's no one that can pick the kid up from school, if the school calls DCFS, they're going to pick that kid up in an instant. So yeah, I think that's going to continue to be a conversation that we have to have with the county. But I think this would really apply more to people whose case has been closed and can fortunately keep the county out of it.
Which is my second part of the question, because once the case closed, we don't have any contact with the client. So what you're suggesting then, as part of our representation, is as cases close, we should be informing clients, that they should be doing these things, which raises the question, because normally we don't inquire of our client their status, and it really puts us in a very uncomfortable position with our clients. What do you suggest? How do we raise these issues? How do we present this information? Because we don't want to raise the temperature of fear.
Yeah. So I think, unfortunately, if there was ever a time when you sort of have to have those awkward conversations, the risk is high enough now that you really should. So without, this would be a ladle policy and something for all of you to decide, but the way that I would approach that is speaking to your client, explaining to them that they have confidentiality with you, that you're not asking this information for any other reason except to offer them not immigration advice, but immigration resources if they need them, that these could be important for their case here because their status is not going to be divulged to the court in any way, and you're never going to divulge that information to anyone, but that as their attorney, you want to be able to defend them and you want to be able to offer them the resources that they might need. And therefore I usually say, I'm so sorry that I have to ask you this, but it'll help me as I work through your case to know, are you documented here in the United States? And in my experience, I'm an immigration lawyer, so it might be different, but in my experience, most people freely offer that information. And if I think, and this is something I've talked with CLC about too, because they also were not in the habit of asking their clients whether or not the client thought they had status. I think it's really important in the Trump era that people are inquiring so that you can properly advise your client about what the actual risks are. And then one of the other things that if you are recommending that people go out and seek resources in the community, just really advise them to go to one of the nonprofit organizations first before they seek private counsel. Much like people who bring private counsel to dependency court, there's a lot of not so great private counsel out there for immigration, and there's also a huge problem with notario fraud, which are people who are not actually lawyers who practice as lawyers, and they can really get your client into a lot of trouble with their immigration case. So just make sure that they know they should at least go speak to a reputable nonprofit organization or a reputable attorney that you can look up on the CalBAR website before making any decisions about representation.
The Mexican consulate is doing it for free.
Yeah, if they're Mexican, the Mexican consulate's a great resource, and that would be one of the places they could go. And if you are a Mexican national, the Mexican consulate will actually pay for pre-vetted attorneys to represent you. So it's a really great resource, and they have an office here, I believe, too, the consulate.
They have
still
the biggest office in the United States.
Yeah, but they have, I think they have a little office here at the
It's on
courthouse.
I think it's on the cafeteria level.
Yeah.
And I think that we will be having a follow-up training with them at some point, so if anybody has any questions specific to that, I think that that will be addressed at some point in the future.
How are we doing on time?
You got a half an hour?
Okay, you want to go on to the voting
Yeah.
rights in the courthouse?
So courthouse enforcement. This is obviously an issue of big interest, hopefully to all of you. Hopefully it's not something that happens here, but we want to be giving good information and advice about what to do if there were to be ICE officers in the court here, and specifically an ICE officer looking for your client. So the Department of Homeland Security maintains that it's perfectly legal for them to access state courts, both civil and criminal, to be conducting enforcement actions. We would disagree with that, and there's definitely some pushback coming, both from the California Supreme Court justices and lots of other important folks. But for now, this is something that's happening. This happened under Obama. I had clients who were picked up, mostly in or around criminal courts, but it's definitely an enforcement tactic that is now being used sort of more freely, unfortunately. Generally, what we've seen so far is that ICE is conducting targeted enforcement in courthouses. So they're not sort of asking everyone for ID, trying to pick up whoever they can. They're looking for a specific person who they know is in court for a criminal or a civil case. That could, of course, change, but the tactics that we've heard about and we've seen are ICE officers showing up, often in plain clothes, seeking a particular individual, often by sort of calling out that person's name, hoping that they respond, and then detaining that person. So if ICE tries to detain your clients, you have a few options, which basically kind of are focused around helping your client assert their constitutional rights in that interaction. So these are sort of the same things that your client should be doing if they were to encounter an ICE officer alone, either in the courthouse or in public, but you, as their attorney, can help them in that situation try to assert those rights. So if an ICE agent is talking to your client, you can identify yourself to the agent as the client's attorney, and you can ask if your client is free to leave. So if your client is free to leave, what should you and your client do? Walk away, right? that's the best case scenario. Most likely, your client is not free to leave. The agent is not going to say that your client is free to leave. If they say that, that means that your client is under arrest, right? So they have to have an arrest warrant, or they have to have reason to believe that your client is present in the United States in violation of immigration laws. That reason to believe can't be based on your client's national origin, the language they speak, other sort of constitutionally protected characteristics, even though that may be occurring. But that's why it's really important at that point, if your client is being detained and arrested, that you help your client assert their constitutional right to remain silent.
And in most cases, the reason that they're going to say they have reason to believe is because before you walked up, your client admitted that they were here in the United States undocumented, which is why the number one thing that we're trying to get out to the community is their right to remain silent in this situation. Whether it's in a courthouse or at your house or on the street, they do not need to divulge any information to immigration officials except to say that I'm exercising my right to remain silent. But as you've probably seen in DCFS reports, people get approached by an authority figure and they start saying all sorts of things, and usually that's the basis for their immigration removal case.
So if that interaction is happening, you can instruct your client not to answer questions. You can tell the officer that you've instructed your client not to answer any questions. And hopefully, if you're comfortable, this is a conversation you can have with your client ahead of time, so they're prepared. They've gone through Know Your Rights presentations, etc.
You've given them the
They're good to go to not answer questions. It's likely that if your client is detained in court, that they'll then be transferred to the ICE Processing Center, if this is in LA, which is downtown at 300 North Los Angeles Street in the basement. You all are not immigration attorneys, so you are not expected to sort of follow them there and try to represent them there. But the immigrant rights community is really concerned about this courthouse enforcement issue. So we would hope that you would either contact the person's immigration attorney, if they already have one and you know who that person is, or the Rapid Response Raids Network to try to get that person connected to counsel as quickly as possible.
And because there is so much fear in the community and we don't want to cause more fear in the community, we are trying to be very careful about how those calls come in. And so I think here, if it were to happen and it were a LATO client, you would talk to Marlene or to, let me see, who are the, Jolene Metzger? Is that, maybe you know whoever, and And with one of those folks, they would actually then contact the Raids Rapid Response. Oh, and Lucia, sorry. And so one of those people, if you contact them and let them know that what's happening, they would then contact me. And what I would do is liaise with the LA Raids Rapid Response Network, which my organization is a part of. We have over 100 attorneys, immigration attorneys in LA, who have volunteered and who are going through a training program with us to do rapid response in the case of any sorts of raids. And as Jordan mentioned, the courthouse enforcement is a huge concern of ours. It's a huge concern of the ACLU, and thank God they just made millions of dollars thanks to the election. And so they are bringing people on to really look at this and see how we can fight back here in California. And so if you contact us and let us know this is happening, we will, if it's happening here, we can send a team down at times, depending if it's an ongoing action happening with multiple people here at the courthouse. But if it's a targeted enforcement and you let us know, we can usually find an attorney who that very day will go down to B18 where they're being held and speak with the client to see what their options are. And also get their consulate involved right away so that if it's the Mexican consulate, they know that they have a national who's been picked up and is being held.
And so most people who I'm seeing in detention are not being picked up at courthouses. We definitely do see people, but this is not sort of the #1 enforcement tactic that's being used right now. Most folks that I'm seeing who are not recent border crossers were transferred from criminal custody because they've committed a certain type of offense that allows them to be transferred, or they were picked up in home raids, which is where ICE goes to their house really early in the morning, knocks on their door, and apprehends people, and now sometimes also apprehends other people in the home as sort of collateral arrests. So just FYI.
And you definitely, look and review at what people should do in the case that ICE comes to their home. One of the things that everyone has a right to do is not answer the door. And this is something that they need to educate everyone in their house, including their children, that if somebody comes to the door, and unfortunately you may have seen Mike Fuhrer, the city attorney, and Mayor Garcetti spoke out about this, but ICE will often just identify themselves as police. So they come knocking on your door and say, this is the police, we're doing an investigation. If you open the door and let them in, you are definitely going to detention if you're undocumented. So at that, or especially if you have a removal order. And so what we are recommending is that no one answers the door except in an emergency to police until they've seen identification that it's LAPD. Because if they open the door and it's an ICE officer, the ICE officer can show up to the window that it is that they are from the Department of Homeland Security, and then they should not answer the door, and they have no legal right to bust your door down or come in unless they had a warrant that is signed by a judge. And you're going to talk a little bit more about warrants, but in 99, I've never seen a case where they actually go with a proper warrant to someone's house that allows them to physically take that person out of their home. But this is really important, especially if you have clients with, multiple people living in their home, that they educate everybody in their home not to answer that door, especially kids. Because a lot of times it'll be your 4-year-old who just opens the door, and then you're done.
Usually if they're asking for permission to enter, they don't have a judicial search warrant, right? Because if they have that warrant, they don't need your permission, but these sort of knocking on the door and asking and pretending they have a warrant. Another tactic we've seen is ICE officers pretending to be probation, which is really scary since folks really have to comply with those probation checks. So again, hopefully your individual clients are getting educated about these in some of the community presentations that Lindsay mentioned, but those are just some things to flag. So I hope none of your clients are ever detained, but if they are, again, in LA, they'll likely be transferred to B18 and processed there. From B18, what happens to them sort of depends on their immigration history. So unfortunately, folks with prior removal orders can be deported fairly quickly. So it's possible that your client could be picked up and removed very quickly. Also, if someone agreed to sign for their deportation, they could be removed very quickly depending on their country of origin. Some folks might be released if they're found not to be a priority for detention. So they could have an immigration case pending sort of against them that they would need to be involved in and get counsel for, but they would be allowed to return home. But unfortunately, many folks, and now more folks, will be transferred to detention centers. So these are the people that I work with. Immigration detention is a very sad place. It's a lot like criminal custody, even though it's technically civil. And in fact, many of the local facilities are contracts with county jails. So it's basically the same conditions as someone who is in county jail serving a sentence or waiting trial, but it's for folks that are in immigration custody. Currently, the facilities where people in LA could end up that are local, there is a big private facility out in Adelanto, which is close to Victorville. It's about 2 hours from here. And then there's three facilities in Orange County that are contracts with the Orange County Sheriff. So there is some information in here about finding someone in ICE custody. So again, this goes a little bit to the question about whether you should be knowing your client's immigration status. If that is a conversation that you've had with your client, it's a good idea to get their A number, which is sort of their case. If they've ever had contact with immigration or have an open case pending or have applied for benefits, they'll often have an immigration court number that's assigned to them. It's 9 digits and it starts with the letter A. And it's much easier to locate a client with that number, though you can also run a search based on name and birth date. You know, it is a little bit challenging to find that.
Almost all of the names, particularly if your client's Latino, are written incorrectly in the system. And so a lot of times if you don't have that A number, the names will be very difficult to find people.
So a lot of my work, again, I primarily work with parents who either have open dependency court cases or who are at risk of dependency court involvement because of their detention. So a lot of my work the past year and a half has involved something called the Parental Interest Directive. So this was something that came out under Obama maybe a few years ago, and that theoretically allows ICE to sort of consider a parent's rights and potential complications to their sort of custody rights as complicated by their time in detention. This directive is currently in force. I think, dare we say, it is probably not going to be respected in the way that we would hope it would be respected under this administration, and it's possible that it would disappear. But it does currently exist, and I think it's really important that people know about it and are also flagging it even for immigration attorneys. If you're in touch with your client's immigration attorney, reaching out to me if your client might benefit, because it really can get sometimes people out of detention and help them sort of continue to participate in their dependency court case, even from detention. So there's certain sort of protections or possible benefits that are listed under the directive. One is hearing attendance. So ICE is required to transport parents to dependency court hearings if practicable. So ICE has never transported one of my clients to dependency court, but they are required to provide telephonic or video appearance if requested and if the court requested. So this is a really important thing, I think, to be flagging in your courtrooms. I don't know how open your judges are to this, but many of my clients have participated by phone mostly, and the ICE officers should be facilitating that for them. It's not hard. So I think that's something to keep in mind and definitely ask for if your client is detained and has an open case. ICE also has to facilitate parent-child visitation. If it's not available in the facility, they're supposed to facilitate it by video, or they're supposed to transfer the parent to a facility that allows for visitation. And most of the facilities in the area do allow visitation. So that shouldn't be an issue from ICE's perspective, as long as you know to ask for it. And then ICE is also supposed to be evaluating primary caregivers, so people with open dependency court cases for release from custody or for prosecutorial discretion. I've had luck getting parents out of detention based on open dependency court cases or DCFS involvement. This is likely a remedy that an immigration attorney needs to ask for. If your client's detained in LA, please call me. I'd love to evaluate your client for this potential form of relief and potentially be able to take that on, because it can be a really helpful remedy for people and really just enable them to obviously participate in their case much more fully if they're not detained. ICE is also supposed to consider parents for parole back into the country to be able to attend hearings or to comply with the requirements of a reunification plan. That's also sort of challenging to ask for, and again might require an immigration attorney, but it has been implemented in the past. I don't know if you want to talk a little bit about it.
Sure, and so, I mean, obviously if people are here detained in the United States, you're going to want, in the context of a dependency case, to figure out ways that that parent can participate. But you also want to consider what happens when you have a parent who is deported back and what you can do if they still have the open dependency case to see that they're still able to participate in their case plan. And so my recommendations on that, if it's Mexico, you're going to have the best luck because you would want to contact the Mexican consulate. The Mexican consulate, especially if it was like a non-offending parent or somebody who was, likely to get reunification with their children, they can actually ask DEEF, which is the equivalent of DCFS in Mexico, to do a plan in Mexico evaluating evaluate the home. But there are other ways that you should be able to ask for accommodations from DCFS to allow your client to continue to participate in their case plan, whether it's through video, Skyping, their therapy sessions, whatever it is. But it's definitely not. I was talking a little bit earlier with some folks about how I remember when I was working in this courthouse, and granted this was several years ago, but I did have one of the judicial officers say, when she saw that there was an ICE hold on the client, oh, well, he's never going to get out, so we might as well make sure that they're with good prospective adoptive parents. And so I think as we move away from that mentality, we really want to be creative, especially because we may have more parents who are being deported, to think about how you can protect their parental interests, even once they're outside of the country.
Ladle was a supporter of, I can't remember what the AV number was, but the governor signed it into law a few years ago. And as you guys all know, people who are just recently out of ICE hold, or clients who've been recently deported, we can ask the court to extend past the 18-month date. So immigration holds and deportation is now part of the 2-5. And thank goodness that we did that a few years ago, since we never knew that we're probably going to be using it every day to extend that time for reunification. So always remember that you have that 2-5 in your toolkit to extend reunification period specifically for clients who are in this situation.
And just one other consideration you might want to think about, especially if you have a parent who's detained, who you think is likely to reunify with their children and that their children would need to go abroad to do that, is working either with the CLC attorney or asking the court to ensure that that child has travel documents. That can delay reunification for many months, particularly from Honduras, because your parent will need to sign that. Both parents, if the child's under 18, need to sign for the child to get a passport. That's much more easily done if the parent's still here in the United States and the consulate can go and see them and get the signature. But I have had cases where children are ready to go back to their parents, but they don't have a passport, and that is even more important if the child is a U.S. citizen, because you don't want to send a U.S. citizen child to reunify with their parent in Mexico or Honduras without that child having their U.S. passport, because they would have no proof that they're a U.S. citizen if they ever want to come back here. So that's also something you want to start to think about in cases where you think the parent might be deported or has been deported.
So if you're trying to request some of these assistances for detained clients, especially like court appearances or visits from children, if it's a county facility, don't contact Orange County Sheriffs. They will say, we don't care, this is a federal detainee, we can't help you. You should contact ICE. And there's actually a mailbox and a contact that I've provided you the email for. I unfortunately don't think they get very many inquiries, because I don't think a lot of people know that these protections exist. So please reach out to them and sort of flag these cases for them. Your clients also can call the drill line, which is the detention reporting information line, and sort of report that they're being denied this telephonic access to their appearance or denied visitation, and people should be reporting those things. And again, I'm also happy to be a resource if I can, if your client is detained locally. And then, yeah, we just wanted to mention the Reuniting Immigrant Families Act, which was just mentioned by Marlene. But there are protections in California law for people parents who are having complications with reunification based on detention or deportation. So I just flagged some of the protections available there.
And so then the last section that we're going to talk about before opening it up for questions is just a very brief, I'm not expecting anyone to start practicing immigration law tomorrow, but I'm just going to give you a very brief overview of what some of the forms of relief that parents might be eligible for. The first, one thing to think about is that most immigration benefits, the way that it's supposed to work is that most people receive benefits through their family, through their work, or humanitarian benefits like asylum. There's other forms of relief like temporary protected status, prosecutorial discretion, DACA, that are more recent. But the ones that might be something that families here would be more likely to be eligible for, the two I want to really focus on are what are called U and T visas. A U visa is for a victim of crime, and one really underutilized area of law is that DCFS and your judicial officer can actually certify that your client was cooperative in the investigation of a crime, and a dependency case is considered a crime that's being investigated. So I've helped numerous dozens of moms, mostly, who were victims of domestic violence in dependency court. Their children were removed, they cooperated, eventually got their children back, but they were a victim of crime who cooperated with DCFS in the investigation by giving information and reports. And then Cecilia Sacco at DCFS signed the certification, and that those women are now all legal permanent residents here in the US. So that's something that you want to keep in mind. I mean, I know that there are hundreds of people who are victims of a crime who also become, who are also parents in dependency court. And if they have cooperated in DCFS, or the judge, who can also sign that certification, can certify to that, they are, prima facie eligible for a U visa in the United States. Another form of relief that people can be eligible for in very similar circumstances is the Violence Against Women Act. This one you'd want to do really quickly, because who knows what will happen with the Violence Against Women Act under the current Congress, but this is very similar to a U visa, but it's for women who've been domestic violence victims at the hands of either a U.S. citizen or a U.S. legal permanent resident. So if the offending parent is a U.S. citizen or a legal permanent resident, and you have an undocumented mom who was a victim of domestic violence, they are very likely, and they've been cooperative with the court, they are very likely eligible for that form of relief. I did hand out that paper with all the community resources on it. If you have a parent in that situation, and again, you're going to have this conversation with them where you inquire, are you undocumented? But if they tell you they are, and you think that they might be eligible, I can tell you that for the nonprofit organizations doing U visas, if you have a mom or a parent who has been cooperative in the investigation, it's like, oh, that's an easy case, because DCFS is very likely to certify a case like that, because all they need to do is look at the DCFS reports, this person was a victim, this person's cooperative, done. And if DCFS for some reason doesn't want to, but the judicial officer really likes your client, ask the judicial officer to certify. They also are, they can be signatories under California, or under the U visa code. So it's something to keep in mind. I think that this really underutilized, and what you can do is go on that sheet that I gave you, look at the agencies. California invested $30 million over the last 2 years to increase the amount of agencies that do these types of cases that help people who are victims of domestic violence. And so if you find one and it says they do U visas, the biggest are Legal Aid Foundation of Los Angeles, Neighborhood Legal Services, all of those agencies that do U visas, send your client over there for an evaluation of their case. There's some other forms of relief. If you have someone who's under 21 and they're a parent, they could be eligible for special immigrant juvenile status depending on their reunification with their parent. That's a little more complicated, but you should always refer to the Immigration Center for Women or Children or any of the other agencies that do SIGs. They might be eligible for that. There's family-based, if the person is a U.S. citizen or if the person is the parent of a U.S. citizen who's at least 21, they might be eligible for family-based immigration to the United States, but that can be very complicated, and in most cases there's other barriers to them getting that form of relief. So really the ones you want to think about that I think would be most relevant here are the U visa, are the VAWA, and potentially SIGs. If your parents, just so you know, in a lot of cases at my office, when somebody has an immigration attorney, they're 5 times more likely to actually obtain immigration relief. And that number only goes up for people who are in immigration detention. The numbers are shocking. At some immigration courts around the country, only 2% of people get relief, and almost no one's represented. Here in LA, on the cases where we actually represent, I think on public counsel's unaccompanied program, they have a 95% success rate. We represent a lot more adults, but our numbers are in the 80s. So if you can get somebody represented, there's a lot of forms of relief that we can pursue that person might have a fighting chance at staying here in the U.S. So just something to keep in mind, and keep pushing back on that mentality. If they have an ICE hold, they're screwed, because it's not true. And so yeah, I would just say look at those community resources. You can always reach out through sort of the designated folks here if you need immediate assistance. or questions. I know I did a presentation like this about a month ago for CLC, and I've gotten some questions from their attorneys about what to do in certain instances, and there's a lot of misinformation out there about immigration law. There's a lot of fear in the community, there's a lot of fear in the advocacy community, and so we're really trying to shine a light on this and make sure that we're doing our best to protect our families. So, enough for questions.
When you mentioned earlier as to what the criterion is for if whatever the allegation is, it could be a basis if it was a criminal allegation, even though it's not charged that way. So since so much of what the department puts in the petition, I mean theoretically, whether it's drugs or child abuse, could be perceived, right, as a crime. My first question is, I know the public defenders a number of years ago got into trouble because the PDs were not advising people of their immigration status. So my question is, you've given us some really good information that we have to engage with our clients now, but do you know if the criminal waivers actually talk about immigration, and should our waivers here in dependency raise some of these issues before clients enter pleas?
So because this executive order just came out in January, it's pretty unclear how they will use that sort of, in immigration law now, there are certain things that can make you ineligible if you admit to facts that could constitute a crime even if you've never been convicted. So that's sort of, this Kafka-esque area of immigration law where you are, talking about it's almost to the point of like, if you've even thought about doing this, that you could then have immigration consequences. For this particular issue, I think that if they were to allege that acts, that resulted in a dependency case were the basis for immigration enforcement, I'm pretty sure that the only way they could do that is if your client admitted them to the immigration officer, because otherwise the immigration officer would have to know the case exists, file an 827 request, because those, everything's confidential here and it can't be disclosed to the federal government. And hopefully under Senate Bill 54 that, the wall between California and the federal government will get that much higher. Instead of the southern border, we'll make it here in Arizona. And that would result in them not being able to access that information. There's a huge push here in the county and statewide to make sure there's no information sharing. But if they filed an 827, which I have seen ICE do before in other cases, and actually in cases where it was for the child's dependency history to get the child's criminal history, if they file that 827, I would think Ladle would want to fight that like crazy because they shouldn't have access to any of that information. But it's another reason why finding out if your client's undocumented is important, so you can make sure that they don't discuss their case here with anyone except you. Because in most cases, the way that it's called an I-213, which is basically the charging document for the immigration court, that's oftentimes filled with information that your client has just offered up to immigration enforcement, and then it's used against them. But in terms of the waiver, I have never seen the waiver myself, so I'm not completely sure, but I think it's definitely something to think about. In criminal court, there's actually another state bill, AB3, that just passed that will increase the amount of resources for immigration consultations within the criminal court. And I think that it is something important to think about how that needs to extend into dependency courts as well.
You had mentioned that the judge can sign, can certify for a U visa. Does that apply as well if it's a commissioner? Is this a bench officer?
I think it would, because they're the judicial officer that's in charge of the investigation within the context, so it should, yeah. I think any judicial officer in California could.
Okay.
Is there a specific form that's available for them to sign or for the DCFS officer to sign?
Yeah, so if you're thinking about kind of helping your client do it, you can also just refer them to the nonprofit agency, but the form itself is called I-918, and you can find it on the USCIS website. You do have to fill out like the facts that make this constitute the basis for a U visa. That's pretty easy, and certainly I think, we could do a U visa training and people could probably do it, but it is, there are a lot of resources online, a lot of manuals that kind of show you how to fill that out. But you can also, if an agency like NLS or LAFLA takes the case, they will also help the person to get the form completely filled out, and then that person can come back to you to have it walked on to see if the judge would sign it, or we just email them over to Cecilia Sacco at DCFS and request signatures. And basically what we do is we fill out everything that we believe constitutes them having the basis for a U visa, and then we attach reports that show that the parent was cooperative in their DCFS investigation. And usually that, any parent who offered up information against the other parent, that's considered cooperation. So.
Other questions? We are just about out of time, so. All right, well, thank you so much for coming.